Thank you. I ask the attorneys and responded in 127-338 in the matter of Eric M. Campbell to please come.
Madam Chief Justice, and may it please the court, Kate Duncan Butler appears on behalf of the Office of the Disciplinary Administrator. I would like to respectfully request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving the respondent, Eric M. Gamble, who has been licensed to practice law in the state of Kansas since 2003. This matter comes today before the court under Rule 223 as part of a summary submission agreement. The parties have entered into this agreement in which they have stipulated to the facts, the rule violations, the applicable standards, and the aggravating and mitigating circumstances. It is the joint recommendation of the parties in this case that Mr. Gamble's license to practice law be suspended for a period of 6 months, but that suspension be stayed for 12 months probation. The probation plan is included in the summary submission agreement and can be found at Volume 1, page 252 of the record in this case. To summarize the facts underlying this case, a wife left her husband in Utah after a domestic incident and brought the children to the state of Kansas. Once in Kansas, in Wyandotte County, she filed a protection from abuse, emergency custody, and later a divorce action. The law firm that represented her was run by her sister, although there was another attorney of record primarily working with her. The husband hired Mr. Gamble for the limited purpose of challenging jurisdiction and venue. After joining the case, Mr. Gamble sent an email in response to a question about selling the marital home to the court and opposing counsel, in which there were allegations of venue and forum shopping and attempting to gain a home court advantage for the wife. Mr. Gamble then subsequently filed motions in all 3 of the cases. In the divorce, he filed a motion to strike and request for sanctions that included the home address of the lawyer's sister, whose law firm was representing the wife. He also filed what were styled as omnibus motions in the petition for abuse and emergency custody actions. These motions, the initial one, there were then 2 amended motions, were filed over the course of a few days. They requested extensive relief. Each was substantially similar to the other, pardon me. In those motions, he included the lawyer sister's home address. He also made unnecessary and objectionable remarks about the sister's shared extended family out of the country and attached newspaper articles regarding that extended family. He requested, after filing the second amended motion, the last of those 3, that the court issue immediate relief. The court declined to do so. Eventually, the court had a hearing at which Mr. Gamble did not offer evidence apart from the citations to the existing record that were in those motions to substantiate these claims within his omnibus motion, and did not withdraw any of the statements made about the wife's sister, the lawyer. Ultimately, the district court found that Mr. Gamble included irrelevant information and inappropriate information in these motions that diminished the wife, lodged inflammatory attacks on the sister and her law firm without any legal purpose, and improperly accused counsel of forum shopping. The district court struck the objectionable material, denied the motions, and ultimately sanctioned Mr. Gamble. Mr. Gamble has stipulated in the summary submission agreement that this was a violation of KRPC 8.4 subsection D, which is engaging in conduct prejudicial to the administration of justice. The motions impugned the judicial process and created an unnecessarily adversarial relationship between opposing counsel without evidence to support the allegations, and it costs the court and the parties time and expense to handle that.
Counsel,
Yes.
I'm not questioning the summary submission, and I understand the respondent has admitted to these violations. But since we're here, I'm curious if you have how would you articulate the line between zealous advocacy that introduces material that a court is going to strike? You know, it's irrelevant, what have you, versus an ethical violation. The rule can't be every time you introduce material that gets struck, you violated the rule, right? I mean, you would agree with that, I
Yes.
presume. So is it just case by, like, is there an objective way to draw that line?
Justice Siegel, in this case, the district court ultimately found that much of this objectionable material was essentially ad hominem attacks, personal attacks on the law firm, the sister attorney. Also, the address of the sister attorney is personally identifiable information, that there was a way to advocate. If the argument was that the wife was living with the sister and therefore venue was improper, there's a way to advocate for that without including her actual full home address in a pleading. And so the question is not, is all irrelevant information going to rise to that level? But when it becomes, for lack of a better phrase, and I apologize, an overwhelming amount, a repeated amount. I believe the district court's ruling says that the sister attorney was mentioned 20 times in these pleadings. When it sort of goes beyond just, this is tangential, but you can see the link to personal, I think that is when we are talking about an ethical violation. So as I said, the joint recommendation of the parties is that Mr. Gamble be placed on probation. It is our belief that the probation plan complies with Rule 227 because it is workable, substantial, detailed, protects the public, and has adequate safeguards to address the misconduct. The probation plan is tailored to what happened in this case in that it requires Mr. Gamble to meet with a practice supervisor and then run pleadings and motions by that supervisor in high conflict cases to help identify what is zealous advocacy and what may be strategically too much, or may end up hurting the client because it is outside the ambit of what is being discussed in the case. Mr. Gamble, in his affidavit of compliance, explains that he has started supervision in July of 2023. He is complying with probation. He's been proactive in that his practice supervisor had an accident, but he has obtained replacement practice supervisor and has been complying with probation.
Maybe I'm getting ahead of your argument here a little bit, but can you help me understand the KLAP resiliency group activities and what that's about? I'm not quite as familiar with that.
Justice Wall, I will admit I am not particularly familiar with the KLAP resiliency program. That may be a question better for Mr. Gamble and his counsel, just because I am not an expert on that program apart from, frankly, its existence. And so I apologize.
No problem.
Just to touch a little bit on the aggravating and mitigating factors that are part of this summary submission agreement. I'm actually going to start with the mitigating factors because compelling to the disciplinary administrator is that neither the judge nor the lawyer sister, as I keep referring to her in this case, wanted Mr. Gamble to lose his law license over this misconduct. The position of those most impacted by the misconduct was a strong mitigator in this case. He lacked an selfish or dishonest motive. He has been participating in the resiliency group to deal with the sort of natural stressors that come with the practice of law. There are character letters in the record, and Mr. Gamble is an active and productive, respected member of the bar. He has demonstrated genuine remorse. He has accepted accountability by entering into this agreement, by being willing to do the probation plan. And he does have prior discipline, but it is remote in time, if not in character in all cases, which again was a mitigating factor.
Does that suggest that had the, I'll say, victim of the misconduct wanted a full bore prosecution, if you will, wanted an indefinite suspension or disbarment, does that suggest that the disciplinary administrator's office would have sought a higher sanction in this case?
I don't believe that, Justice Stiegel, but I believe sort of in determining what is appropriate, or rather the appropriateness of something like probation, just knowing that those most impacted would essentially rather see the safeguards of probation than something like a suspension is telling. My understanding, I did not try this case, I was not the attorney who put together the summary submission agreement, is that both of those parties recognize the work Mr. Gamble does in the community with which he works. And so that was just an important part.
So is it fair to say that considered sort of in the abstract prior to considering aggravators and mitigators, that your position is this conduct would warrant a suspension without probation?
I would say that is, given that there was also a prior suspension, I don't think that's an inaccurate statement. I think oftentimes the starting point is what the underlying discipline should be, and then the appropriateness of probation once that underlying discipline, if it's suspension, the length of suspension, is the sort of layers of consideration. Thank you. So as I mentioned, there is prior discipline in this case. Some of it is similar in conduct with, again, sort of the not completely recognizing perhaps the line between zealous advocacy and overstepping zealous advocacy. And again, this probation plan is tailored to address those concerns and issues in this case. And so if this court does not have any other questions, I would simply ask that the summary submission agreement be approved and that the joint recommendation of a 6-month suspension stayed for 12 months probation be imposed in this case.
I have a couple, oh, go ahead. So I'm looking at a letter that that is actually from Mr. Gamble's other counsel, Ms. Belquist, and it makes reference. It's dated in August of 2020. And when did this incident occur? Just remind me.
The underlying conduct?
Uh-huh.
It started in, I believe, no, it started in early 2020. I believe
Okay.
January is when he joined.
Okay, so it's, and it says, it is no secret that Mr. Gamble has a previous disciplinary history, and then it asks that the same person who is investigating that case investigate this case, right? That's
I
what-
don't have that letter in front of me, Justice Sandridge, but I have no reason to disbelieve that's what it says.
So it kind of makes it sound like the previous complaint was not remote in time.
So that may be referencing other complaints, which,
Oh. Okay,
I don't have the
Okay.
letter in front of me, so, but I am talking about previously formally imposed discipline that would have, in fact, with the exception of his previous diversion, there was a formal complaint, a formal hearing, and the whole process.
okay. And so just as a general statement, nothing to do with this case, but as a general statement, you don't consider complaints that aren't brought to hearing.
Correct.
How does that work?
Justice Standridge, until and unless there is discipline imposed, which is, I believe, begins with an informal admonition, diversion, or then suspension, beyond just, if there's a complaint that is then when it reaches the review committee, does not go forward for formal discipline, then it is not part of, that's in fact confidential. And so it is not part of those considerations.
Okay, so if there is something pending, do you wait to go forward with us until that pending?
I am not the individual within our office who sort of manages all of that, but my understanding is if it is known that an individual has several pending matters, cases may be held and considered together, because if ultimately the determination is that it is to go to formal hearing, to try those together rather than to have, several, especially if it's similar allegations of misconduct. Does that make sense?
Yes, thank you.
I'd like to key off of Justice Stiegel's question as to, where we draw the line between zealous advocacy and improper conduct, because KRPC 8.4D is one of the more nebulous aspects of the disciplinary code. It's professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. And in wrestling with that question that Justice Stiegel raised, in my mind, in this case, would you agree that some of the complication there is that we have a lot of very serious and emotionally charged things going on in this case. They had originally lived in Utah. A statement had been allegedly made by the wife that she was going to take the kids to Mexico. There was a terrible incident in Mexico, family incident such that people were killed. She wanted to take the kids. He didn't want to take the kids. Then she picked up the kids from school and left and went to Kansas. And then the sister lived in Johnson County. The case was filed in Wyandotte County. And some of the pleadings indicated that wife lived in a confidential place. So we have legitimate issues of potential forum shopping in that I still don't understand the link with Wyandotte County. But also the home state, which place should have venue under the UCCJEA, and whether or not there had been some alienation. You know, there were potential serious issues and emotionally charged issues against the wife also, right? And so doesn't that make it much more difficult within this the context of a case like this to determine where the line is between advocacy, because all those things would have to be proved and shown with evidence, and going too far, such as listing PII or ad hominem or personal attacks.
Hey, Justice Lukert, I see that I'm out of time. May I answer Justice Wilson's question? Justice Wilson, I don't think anyone is arguing that the issues about is venue and jurisdiction proper under the UCCJA or the charged family concerns with what was going on in Mexico were inappropriate to raise in the context of this case. But there were ways to raise it without including PII, without including sort of the additional potentially controversial information about the family. It's important to note that at the protection from abuse hearing where both the husband and wife testified, and I apologize, I do not remember which exhibit number that is, but it is within the record, there were references and testimony about what had happened in Mexico. And I believe Mr. Gamble's motion even cites to when the husband discussed that. There was therefore not a necessary reason, a legal purpose for bringing up the social and religious views of the extended family, of attaching newspaper articles, one of which included a family incident from the 70s that is potentially controversial and not from the record before us linked to what had happened in November with the violent incident, which seemed to be a random act of violence. There were ways to bring up, the not knowing where the confidential address is, because in PFAs, addresses are confidential of the protected party, and whether it truly was Wyandotte County without rising to the level of the accusations, the personal accusations of forum shopping, and there's a level of essentially suggesting that the sister was meddling in the affairs of this family improperly. In emotionally charged cases, it is natural that parties will become very heightened and oftentimes add information that perhaps is only, unless you're living the case, does not seem to be relevant. But this is beyond that because it was very personal. It was potentially controversial. And again, the PII is also an important aspect of it, is that the necessity of including her home address. There really was none. He could have alleged the sister lives in Johnson County and they're living with her.
May I ask one more question, Chief? All of that was considered in your understanding that the agreement is that the respondent did go too far in doing some of those things. and also all contained with what was considered in suggesting the discipline that you jointly discussed.
Yes, so the stipulation is that those facts that I just laid out, and they are laid out in the summary submission agreement and supported by the exhibits in the record, is that that was a violation of KRPC 8.4D, which is also part of the stipulation. And all of those elements were considered in making this joint recommendation of probation and the plan that is really sort of centered on making sure that a neutral and detached person is reading pleadings in highly emotional cases like this one to assist Mr. Gamble in making strategic decisions about what to include and what not to include.
Thank you.
Questions? Thank you.
Thank you very much.
Good morning, Christopher McHugh for Mr. Gamble. I will try to be as brief as I can because Mr. Gamble does want to come up and address you as well and answer some of the questions that you've asked. First, though, I would like to state, because of some questions on prior discipline and prior cases, Mr. Gamble's prior case was 10 years ago. So it was very remote in time. It was a decade ago. I'm not familiar with the letter that was referenced either, so I'm not going to speculate, but there were several complaints and investigations that were related to this and involved other parties that we were seeking in discovery at one point. So I don't know if that letter is related to that or not, but I don't believe it was related to any discipline or investigation of Mr. Gamble, any additional investigation. I don't know how far to get into this, but I think it's important for the court to understand the situation that we were in before we got here from a legal position. First of all, Mr. Gamble was not sanctioned by the district court. His client was sanctioned by the district court. And that may seem like I'm splitting hairs, but there's an important effect that comes off of that. Mr. Gamble did not have the decision on whether to appeal that. It was not his case to appeal, and his client decided not to appeal that sanction. So he didn't have control over that. And in these proceedings, these ethical violation proceedings, that order, that judgment then becomes a legal presumption. Under rule, and I believe it's Rule 216, but I'm not sure about that, it becomes the law, the facts of the case. The judge's decision is presumed to be accurate and true and right unless it is rebutted. Our plan at the panel level was to rebut that with legal experts. Some attorneys that are barred in Kansas that do domestic work that would come in and say that what Mr. Gamble did was relevant. There was a legal purpose for it. We were not allowed to do that. So we weren't, it's already been brought out here, I think, in questioning, but listing the home address, there was a purpose.
What do you mean you weren't allowed to do that?
That evidence in a pretrial hearing was rejected.
By the panel?
Correct.
Okay.
So that, not to put too fine a point on it, that leads us here. And that's not to take away from anything that Mr. Gamble's about to tell you about acceptance of responsibility, because he does accept responsibility. He is accepting responsibility, and we are agreeing, pursuant to this agreement with the ODA, that he did overstep. I think that's a good way to put it.
Let me press into that a little bit. I'm sure you appreciate and recognize the internal contradiction between preparing a defense with legal experts to demonstrate the relevance of the material and the appropriateness of the material, and then filing a summary submission where you admit the opposite.
Let me try and nuance that a little bit and make those fit together.
Okay.
Because I do in my mind. They really do. Talking about this stuff being relevant, it can be relevant and still be overstepping in the way it was presented. And I think my opposing counsel talked a little bit about that.
Help me understand that.
Don't go in to a court trying to be persuasive and be overly aggressive in the way this case was handled. This was not persuasive to the court. In fact, it pissed the judge off. I'm sorry.
Yeah,
I
so it might
apologize.
be, I mean, it could be negligent and it could be bad lawyering. That's what you're saying.
I think,
But if
it-
it's relevant evidence, how can it ever be an ethical violation?
I think, given the position that we are in,
And I appreciate the
it
position. you're
was,
in. I
it was
understand.
very reasonable and still is very reasonable for us to say, we ethically stepped over the line. We were too aggressive and it interfered with the administration of justice. Regardless of our
You
position.
were
on-
too aggressive in asserting relevant evidence that was favorable to your client's client.
Correct.
Okay.
Correct. I think that's the position we're in. And legitimately, I think you're going to hear Mr. Gamble come up here and he's going to honestly say, I wish I would have done this differently. And I do think he's going to say, I think, that it did impact on the way the case was handled. And it did, you know, I am torn, sir. I am torn because one side of me as a litigator of 20 years wants to say, you don't want to make a litigator scared to make their case. And scared to make someone upset or scared to take a certain position. But at the same time, I don't like the way Mr. Gamble presented this case as a litigator. And I think there is a fair argument that he overstepped.
I mean, ipso facto, he made a bad case because of the outcome, right?
He was not persuasive. He was, I don't want to characterize it because I don't want to put words in his mouth, but it made several people very angry and we're here now. And we didn't have to be here. That's how I see
Let
it.
me see if I can help you out.
Please.
Ms. Duncan Butler said, you listed the sister's address in the pleadings. Now, knowing this is, someone who's very angry now knows exactly where the sister lives. And it could have been appropriately said by saying you have reason to believe that the respondent could say, mother was living in a county other than Wyandotte County. She had lived in Utah, and there is, and we have potential forum shopping here because there is no link, legal link between the county where she lives and the county where she filed. I mean, it's said longer, but you don't have that personal information.
Correct. That could have been done. It would have been a better way to do it. And it would have been much more sensitive to the party's perspective. I have trouble with that particular piece of that particularly being troublesome here. I have more trouble, frankly, with the tone and the presentation and the way some of these things were said and the confrontational nature that didn't have anything to do, was unnecessary in the
I mean,
presentation.
I presume that you're not saying that the address was irrelevant to the legal issues being presented.
I can't say that.
Ah.
Yeah, I can't say that, but I can say that being too aggressive in a case can affect the case. It's not persuasive, it's not helpful, and I can see where it rises to the level of an ethical violation.
What about the relevancy of the religion and the relevancy of the initial murder? I mean, like 10 years before the more recent one that led to the argument about going to the funerals.
Yeah, I don't remember, I go off of Judge Mahoney's order, sanctions order, and what he pulled out, and I don't think those were in there, or at least not quoted, or I don't remember those specifically. But yes, I think that's a good example, generally speaking, of going too far, being too aggressive, being too zealous. That's all I have. I do want to give Mr. Gamble a chance to speak here. I would close, though, by urging the court we have worked very hard on this case. It has been hard to come together and come to a consensus and a resolution that everybody thinks is appropriate, including Mr. Gamble, including myself, including the Office of the ODA. So I want to emphasize and let you know about that work, that it took a long time to get here, but we all worked together to get here. The probation plan is going quite well, and there's no reason to believe it won't continue to go well. And considering the really outstanding mitigating factors here as well that I draw your attention to, I just urge you to accept the resolution that is being put forth by all parties.
Counsel, was there any effort among the parties to specifically identify those things that occurred that were over the line? Or is that something that was just a little more of a negotiated agreement, that there were some things that went too far and so that we could go on down the road?
It was very much the latter. For better or for worse, we did make that effort. There wasn't a common ground there, and we needed to get to a resolution that made sense to everyone. So we made that a little vague, I'm afraid.
So I entirely appreciate what you're describing, which is from you, your client's perspective, the Office of Disciplinary Administrator's perspective, wanting to find a way to move on down the road, I think, as Justice Wilson just said. The one thing that doesn't consider, and it's not your job to consider, but it's our job to consider, is the precedential effect of just sort of stamping, signing off on an agreement. And I'm not suggesting you or the Office of Disciplinary Administrator has any responsibility to consider that. But since you're in front of us, I would just ask you to respond to, is there a concern that there's a precedential effect of this agreement that might distort the law in this area?
I'm always concerned about that in these types of cases where you have, and in the mitigating factors in the joint submission, you can see that we've agreed that the motive here was not pure, but it wasn't improper, that we agree that Mr. Gamble was trying to represent his client in a way he just went overboard. So I'm always, having litigated for 20 plus years, I take a lot of positions that make a lot of judges mad. I want to feel comfortable doing that as much as I can and feel like they're not going to call me out and endanger my license. At the same time, I would not present to this court or any court a resolution of a case that I didn't think had a factual basis and I didn't think you could get there solidly. So I am not presenting something to you that I want you to rubber stamp. I cannot identify specifically the straw that broke the camel's back here. But I think in concert, what you have before you is enough where you're not putting a rubber stamp on this. I think Mr. Gamble will come up here and say he went too far. He was too aggressive. And it stepped over the line of an ethical violation. And whether that was way over the line or just over the line, he's willing to admit that. And I think you should take it at face value.
Counsel for the ODA's office, and I want to thank attorneys for representing me through this very difficult process the last 4 years. Chose to agree to a stipulation to a violation in this case because I thought it was the best thing to do for not only myself, my family, my practice, my clients that I represent, for a resolution that would allow me to accept responsibility for some of the language that I used, overzealousness, you can call it, being a little too aggressive, not being as sensitive to intricacies and the emotional issues that were present in my representation of this particular client. I thought what I was doing was for a good cause and for the best of the client. I believed that my job as an attorney and a counselor is to educate the court, to research the issues, present the best case you can for a client. I did include information, public information from the internet. Some of the information was taken from a Utah case, a divorce case. I apologize. A Utah case that was open, and the documents I received from another attorney, I included those in my arguments in my memorandum. I have no ill will towards this woman. We've worked together many times in the past, but I did apologize to her. I apologized to the court recently as part of my probation plan. And I take responsibility for my efforts and my representation for my client. I think that in the family law courts, sometimes cases can get very heightened and a lot of emotions run high. Justice Wilson, when I was legal aid, you were appointed on the bench and I was with legal aid, and that's how I came to start practicing family law, and I practiced it for 20 odd years now, and it's never a dull moment. And but sometimes you have to take unpopular positions in your representation, and that's what I did. And appreciate the questions prior to my coming up here, and if the court has any other thing that or issues that they want to know about. Or
Can you help us out a little bit to, again, key on Justice Stiegel? Can you articulate to us how you would say you engaged in conduct that was prejudicial to the administration of justice by way of misconduct?
believed I caused my memorandum and my communications with the court caused highly intense emotions by having to state facts, make arguments, and it put a lot of pressure on people. And I didn't do it to be mean or to be spiteful. I did it because I thought those facts were relevant to advocating my client's position. And I was tasked with a difficult job in this particular case, this county. And I just tried to do the best I could. And I think I went a little too far and caused prejudice in the case that was prejudice to the administration of justice. And I accept that. I'm not perfect.
A practical question. Daniel Parker, what area of practice does Mr. Parker?
He does criminal defense for Spanish speakers.
Criminal defense? Is he familiar at all with family law?
No, and I think that's a good thing because it gives objective perspective. I think but Mr. Parker is currently unable, and I have
I'm sorry.
I have another supervisory that does this family law.
Oh, who is that?
Angela Trimble.
Angela Trimble. And is that in the, I guess, is there a new plan that was filed?
There was an affidavit.
Okay,
Attested to
Angela
the-
Trimble, and then, and is she in Wyco?
Yes, ma'am.
Okay, and is your primary practice in Wyco?
It's kind of spread out. Johnson, Wyandotte, Jackson.
Okay,
Can you tell me about the resiliency
Yes,
groups?
it's an online, they do it twice, 3, 4 times a month, depending on the person who's presenting it, their schedule. It's an opportunity for lawyers who have faced disciplinary issues or currently facing disciplinary issues, therapy amongst colleagues, going over life issues, practice issues, Uh, The moderator gives a lot of good practical tips, books to read, meditation, practical things that lawyers who routinely are engaged in high conflict, they can bounce ideas and just generally talk to other lawyers and encourage them. I've enjoyed it. I mean, there's people in there that I can really relate to and are going through a lot of issues, and I do enjoy those sessions. Wish everybody health and goodwill, and happy early Mother's Day weekend for the mothers.
Unless this court has any particular questions, I would waive my rebuttal time.
You know, I just have one question. So when we get down to it, well, would you agree with Mr. Gamble that, the prejudice to the administration of justice beyond, putting in PII, that it, he caused high emotion and put a lot of pressure on people? What else would there be?
Justice Sanders, I think it increased the adversarial tenor of the proceeding in a manner that was prejudicial to the administrative justice, because it became not about those issues that Mr. Gamble was trying to raise. It became more personal, more intense and emotional than necessary, and ultimately cost more time, resources, and expense, including for Mr. Gamble's own client. And I apologize for misspeaking that he was sanctioned. That was my mistake, and I apologize. For his own client, in sort of separating the personal and the irrelevant information from the actual issues that were being raised. And so that is the prejudice as well.
Is it the view of the ODA that increasing the adversarial tenor is a violation of the rules of professional conduct, as opposed to sanctionable conduct, that a judge is just controlling the courtroom and you're causing high emotions, you're causing, adversity, you're causing more money to be spent, your motion practice is higher, because as a litigator yourself, with a history of litigation, many, many years, this is not unique. And if we, I'm asking you, if we make this our standard, how many cases will we have?
Well, Justice Sanders, I would back up a step to your initial question, which is it sanctionable or an ethical violation? It can be both. There are sanctionable things that happen in cases that are also ethical violations and come before the disciplinary administrator, and it, are handled through this process. Every case is different and sits upon its own facts. And I am not pulling the citation out of my head, but there's been a recognition by this court of that fact. And so what is, is this uncommon? No. Is this beyond what is, the only way I can think of it is like stair steps of, yes, it is not uncommon in family law for an attorney or a party to occasionally step beyond what is zealous advocacy. However, it is leaping beyond, going up 2 or 3 stair steps.
This is leaping?
It is, I think, more severe than an ordinary case, given the concerns with the PII, given the increase of adversarial conduct and the personal attack against.
How familiar are you with family law?
I did practice some family law when I was in private practice. But there is a difference, I think, between intense information and argument about the party's behavior and then looping in a third party, in this case, the sister attorney, and not projecting, that's not the word, but then making accusations against that person and sort of drawing them in.
But why shouldn't the judge just have control over that? Why are we turning that into an ethical violation? I mean, because, as Justice Stiegel said, this is opening the floodgates. If all of a sudden these are all ethical violations for overzealous advocacy that brings in irrelevant information. Because it just seems like, I mean, if, in a criminal case, in any case, it's like, you bring that in, objection, Your Honor, that's irrelevant, or, I mean, irrelevant evidence is introduced all the time or attempted to be introduced all the time. If that happens in a criminal trial and a lawyer elicits irrelevant information about a victim, and before they can finish, it comes into evidence and the objection is, sustained. So it comes out of the transcript. Is that now an ethical violation?
Chief Justice Lukert, I see I'm out of rebuttal time, but may I answer Justice Standridge's question? Again, Justice Standridge, the issue here is not simply that the information was irrelevant. It was that it was objectionable. It was beyond just including irrelevant information, but it got personal. It brought in potentially controversial family information that was.
I'm not arguing it wasn't wrong. My issue is, that it's attorney misconduct that can be controlled by a judge versus, rising to the level of professional misconduct where you can punch somebody's ticket.
My answer to that would be that just because a judge is able to sanction and perhaps control a situation does not take away from the attorney's duty to comport with the rules of professional conduct, does not undermine our duty as our office to ensure that those rules are being followed, to investigate and then go forth with cases where there were violations. It's reminiscent to me, to pull from my criminal law background, of State versus Sherman and prosecutorial error versus misconduct. There are situations that don't rise to the level of misconduct, but I would imagine that if a prosecutor was committing the kind of misconduct that brings them before our office, this court would still consider whether it causes reversible error in the criminal case and vice versa. There are parallel tracks, and there are probably, I don't have, the full historical knowledge of every case that's been before our office, but I'm certain that there are times attorneys were sanctioned and they don't end up standing here because the finding was that the ultimate determination by the review committee or whomever was that while their behavior was sanctionable, it was not to the level of misconduct, but it can also be sanctionable and be so overzealous, so prejudicial, so inappropriate that it must also fall under the rules of professional conduct.
So it's the ODA's position today that it was so overzealous, so prejudicial, and so, I forgot the last word, that's what brought us here today.
It is the joint position of the parties and their stipulations that Mr. Gamble's conduct in this case was a violation of KRPC 8.4D.
Thank you, counsel.
And I have two I know we're way over time, but I do have two, I hope, really quick questions. Would you agree that the summary submission does not include an admission that the evidence introduced was irrelevant?
I was just reviewing the summary submission agreement and I
have it.
My binder very quickly.
Sure, I have it in front of me. And again, as I read it, one of the admissions is that the district court found some of the evidence to be irrelevant, but there is no admission that the evidence was irrelevant. Would you agree with that?
Justice Siegel, I would agree with that. I just double checked.
So then my second question is, would you agree with me that it is not an ethical violation to introduce relevant evidence just because it contains PPI? There's no rule against bringing forth relevant evidence that contains PPI. That would hamstring half the trials that happen.
I am not able to fully recall the rule on how PPI is to be presented in pleadings and such. My recollection is that it needs to be redacted, but I may be incorrect on that. And if I am, I apologize, but it is,
There are a few specific rules that most, and again, maybe both of us are flying by the seats of our pants here, but that relate directly to things like names of minors. But my recollection is those rules are quite narrow. I
think
mean,
if-
in a collections case, for example, you got to include count numbers.
Right.
That's
mean,
PPI.
Yeah, Justice Siegel, I would say, if you're asking if there is a per se, no PPI can ever be mentioned, then I would agree with you. However, in a case like this, that is involving protection from abuse, a protection from abuse case, allegations of domestic violence, and the fact that the person whose PPI was being placed in this is not just, she's not a party to the case, she's a third party, that sort of changes the analysis
How?
from the person.
Is there any rule that says that?
Again, I would have to look, like you, at the exact rules regarding PPI that I don't have memorized, and I apologize.
Well, if there is no rule that says that, would you agree that there's nothing at all wrong introducing such relevant evidence that's not barred by some rule?
I think there are ways to do it that are not also have the auspices of a personal attack.
There's not been much mention, I guess. I'm wondering what part the Utah court order comes into play. As I understand it, and maybe I'm going back and looking to see, maybe I drew conclusions from reading that, and I see some ambiguity, so I may have drawn improper conclusions. But I'm looking at the formal complaint as it walks through, and I think what it was referring to in paragraph 7 of the formal complaint is the Utah order about the emergency hearing, in which the judge made some findings that not Mr. Gamble, but another attorney had filed documents that misled the court. And then we have essentially Mr. Gamble filing those same, or many, and some of the same documents later in the Kansas court. That come into play in what we're talking about here, or am
So-
I connecting dots that don't connect?
My recollection, Justice Lickert, and I don't have picture-perfect memory of the Utah order, was that the misleading information was that the Utah documents filed asserted that the husband there was nothing pending in Kansas when the husband did have information about things pending in Kansas. That's my recollection as I stand before you. It could be a misrecollection, and if it is, I apologize. But it is accurate that Mr. Gamble, some of the information that was raised in the Utah divorce about the extended family is the information that Mr. Gamble subsequently also included in his motions here. But, you know, the Utah case is, that part is its own thing.
Thank you to all of you for your arguments. Court will take this matter under advisement.